Are you still collecting 2 months' rent as a security deposit? If so, you may already be out of compliance. Starting in 2025, California has overhauled its security deposit laws. These changes affect every landlord, and failing to follow them could mean losing your right to make deductions and even paying double damages to tenants. Today, I'll break down exactly what you need to know about AB 12, AB 2801, and SB 611, and what you must do to stay compliant in 2025. Before July 2024, landlords could collect up to 2 months' rent as a deposit for an unfurnished unit, and up to 3 months for a furnished one. That's no longer the case. California lawmakers have capped deposits, tightened documentation requirements, and expanded tenant protections. Let's start with the most significant change, AB 12. As of July 1, 2024, security deposits are capped at 1 month's rent, period. This applies to both furnished and unfurnished rentals. There is only one narrow exception. If you're a small landlord, a natural person, or an LLC of natural persons, and you own no more than 2 rental properties totaling 4 units, you may still collect up to 2 months' rent as a deposit. But outside of that, the 1-month cap applies across the board. Next, AB 2801, which kicks in during 2025. Beginning April 1, 2025, landlords must take dated photos at move-out, both before repairs or cleaning, and after. Those photos must be shared with the tenant. And for any tenancy starting on or after July 1, 2025, landlords will also need to take and keep move-in photos. Here's the important part. If you don't comply with these photo requirements, you lose your right to make any deductions from the deposit. That's a huge risk if you're not documenting properly. Now let's talk about SB 611 and related updates. Landlords can only deduct costs that are reasonably necessary to restore the unit to the same condition it was in at move-in. That means no blanket deductions for things like carpet cleaning unless it's truly necessary to return the carpet to its original condition. Normal wear and tear is not deductible. Another protection. If you itemize damages during a pre-move-out inspection, you can't suddenly add new charges later unless the damage happened after the inspection or was hidden at the time. And for service members, if you charge above the standard deposit, the lease must explain why. If the tenant moves out without arrears, you must return any excess deposit within 6 months. Don't forget about inspection rights. Landlords must offer tenants a pre-move-out inspection within the last 2 weeks of tenancy. During that inspection, you're required to give the tenant an itemized list of issues that could result in deductions, and the tenant has a chance to fix them. You may only deduct for damages that happen after the inspection or that couldn't reasonably be seen at the time. Once the tenant moves out, you have 21 days to return the deposit in full or send an itemized deduction statement with receipts or estimates. If you use an estimate because work isn't finished yet, you must provide the final receipts within 14 more days. Failing to follow this timeline, or withholding a deposit in bad faith, can result in the tenant recovering not just their deposit, but also up to twice the amount in damages. So here's the bottom line. The deposit limit is 1 month's rent, with very limited exceptions. Starting April 1, 2025, photos are mandatory at move-out, and after July 1, also at move-in. Only reasonable, necessary deductions are allowed, no automatic carpet charges. Inspections must be offered, with itemized lists given, and you must return the deposit within 21 days, or face serious financial penalties. These updates under AB 12, AB 2801, and SB 611 are already in effect or coming fast. Landlords who don't adjust their processes will face compliance problems and possible lawsuits. If you'd like a step-by-step compliance checklist for 2025, check the link in the description. We've put one together for landlords across Southern California. And if you have questions, leave a comment below. Don't forget to subscribe for more updates on California rental law. and stay ahead of the changes that matter most to landlords.